You're on the floor at work, a normal Tuesday. Then the door slams open. Men in tactical vests, badges, radios crackling. ICE is in your building. And in the next 60 seconds, one wrong word or one wrong action determines everything that happens next. Every single day, across warehouses, restaurants, construction sites, and factories in America, workers make one critical mistake when ICE arrives. They think cooperating means answering questions. They think talking helps. They think being honest protects them. But the law doesn't work that way. In a workplace immigration enforcement action, your words are not your shield. They are the evidence. I've analyzed hundreds of workplace immigration cases and studied the Supreme Court rulings that define exactly what ICE can and cannot do inside your place of work. I've identified 4 critical mistakes workers make in the first 2 minutes of an ICE raid. And I've found the exact responses that protect you under the United States Constitution. Responses backed by established law, not opinions. Get one of these wrong, and you hand agents the legal justification they need. Use all 4, and your constitutional protections stay intact. This is educational content only. It is not legal advice. For guidance specific to your situation, consult a licensed immigration attorney immediately. Let's break down the 4 mistakes and the 4 exact phrases that protect you. Mistake 1. Answering "Where are you from?" or any question about your status. The mistake. ICE agents walk in. They approach workers one by one. The question sounds simple, conversational. Where are you from? Are you a citizen? Do you have papers? Most people answer. They think it's routine. They think saying the wrong thing is worse than saying nothing. They say a country name, a city, a status. And in 10 seconds, they have provided agents with exactly what they needed to justify detaining them. The scenario. You're working a shift at a meatpacking facility. ICE enters with an administrative warrant. An agent approaches you at your station. He's calm, polite. "Hey, where are you from originally?" You say you're from Guatemala. You've been here 12 years. You have a work permit that expired. That one answer, where you're from, has now given the agent reason to ask for your documents. The conversation escalates. 30 minutes later, you're in a van. Why people do it? People assume that answering sounds innocent. They think silence looks suspicious. They think a friendly tone means no danger. But ICE agents conducting worksite operations are not having a conversation. They are investigators gathering evidence. Every answer builds probable cause for further questioning, document requests, and detention. Legal reality. Here's what most people don't know. The 5th Amendment to the United States Constitution protects every person on American soil from being compelled to be a witness against themselves. Not just citizens, everyone. In Zedvitas v. Davis, 533 U.S. 678, decided by the Supreme Court in 2001, the court affirmed that the Due Process Clause applies to all persons within the United States, whether their presence is lawful, unlawful, temporary, or permanent. You do not lose your 5th Amendment right because of your immigration status. That right belongs to you the moment you are on American soil. Evidence problem. Any statement you make about your nationality, your country of origin, your status, or your documents is a statement that can be used against you in immigration proceedings. Immigration removal cases are civil, not criminal proceedings. The exclusionary rule that protects defendants in criminal court from illegally obtained evidence does not automatically apply in immigration court the same way. That means your words carry enormous weight. Once you say them, they belong to the record. Agent psychology. ICE agents conducting workplace operations are trained to approach workers in a non-threatening, conversational manner. The Supreme Court addressed this directly in INS v. Delgado, 466 U.S. 210, decided in 1984. In that case, the court acknowledged that agents move through workplaces, approaching employees individually, asking brief questions. The purpose is to generate responses that provide the justification needed to escalate the encounter. A friendly question is not a friendly question. It is the first step in a legal sequence. The correct move. Here is phrase 1. Say this calmly, clearly, and without aggression. I am exercising my right to remain silent. That is it. 4 words. You are not being rude. You are invoking a constitutional protection that has been affirmed by the Supreme Court to apply to you regardless of your immigration status. If the agent continues asking questions, repeat it. I am exercising my right to remain silent. Do not explain. Do not say where you are from. Do not say anything else. Why it works. This phrase explicitly invokes your Fifth Amendment protection. It creates a record, if there is body camera footage, if there are witnesses, that you did not voluntarily provide information. You asserted a constitutional right, and asserting a constitutional right cannot itself be used as evidence of guilt in a civil immigration proceeding. Bottom line, never answer questions about your nationality, your immigration status, or your country of origin during a workplace ICE action. The only answer is, I am exercising my right to remain silent. Mistake 2. Allowing agents into private areas without asking for the right warrant. The mistake. ICE agents arrive at the front door. A manager panics and opens everything: back offices, storage rooms, employee break areas, locker rooms. Or a worker, frightened, leads agents through a door they could not legally pass through on their own. The moment that happens, the Fourth Amendment protection for those spaces evaporates. Consent given under pressure is still legally considered consent. The scenario. ICE arrives at a restaurant. They show the manager a document. The manager, terrified, holds the door open to the kitchen and says, "Come on back." The agents walk through. They were not legally entitled to enter that private space without a judicial warrant, but the manager opened the door. Courts will treat that as voluntary consent. Every worker in that kitchen is now in a space that ICE entered legally because someone held the door. Why people do it. People assume that any official document means full access. They think refusing will make things worse. They think their employer has the right to let agents in anywhere, and that resistance is futile or illegal. None of this is accurate. Legal reality. The Fourth Amendment protects against unreasonable searches and seizures. It applies to workplaces. ICE agents are legally permitted to enter public-facing areas of a business, lobbies, reception areas, public sales floors, without any warrant at all. But to enter private areas of a workplace, areas that are not open to the general public, agents must have a judicial warrant. Not an administrative warrant, a judicial warrant. This distinction is critical and widely misunderstood. ICE agents frequently carry what are called administrative warrants, Form 1-200, a warrant of arrest for immigration purposes, or Form 1-205, a warrant of removal. These documents are issued internally by immigration officials. They are not reviewed or signed by a federal judge. They do not grant authority to enter private spaces. A judicial warrant must say U.S. District Court or the name of a state court at the top. It must be signed by a judge. If the document an agent presents does not meet that standard, it does not authorize entry into private areas of the workplace. Evidence problem. If a worker or employer opens a private area voluntarily, even under the pressure of an ICE presence, courts have consistently treated that as legal consent. Whatever agents find in those private areas becomes part of the record. You cannot challenge that evidence later as an unlawful search if you or someone in authority opened the door. Agent psychology. Agents know that showing up with authority, badges, and tactical gear creates immediate psychological compliance. Most managers and workers will open doors without asking what type of warrant is being presented. Agents count on that compliance. They do not always volunteer the distinction between an administrative warrant and a judicial warrant. It is your job to ask. The correct move. Here is phrase 2. This one is for anyone in a position to interact with agents at the entry point. What type of warrant do you have? Is this a judicial warrant signed by a judge? If they cannot produce a judicial warrant, say clearly, I do not consent to entry into private areas of this workplace. If you are a worker, not a manager, and agents are moving through the space, you do not need to guide them, assist them, or open doors for them. Your silence and stillness is your protection. You are not obstructing them. You are simply not consenting. Why it works. This question forces agents to identify the legal basis for their access. If they have a judicial warrant, they can enter, and you must not physically obstruct them. If they only have an administrative warrant, your documented non-consent becomes part of the record. Any search conducted without proper authority and without consent can be challenged in immigration proceedings, even though the exclusionary rule applies differently in civil proceedings than in criminal ones. Bottom line, never assume any document an agent presents authorizes full access to the entire workplace. Always ask whether it is a judicial warrant signed by a judge. If it is not, Clearly state you do not consent to entry into private areas. Mistake 3. Handing over documents without being ordered to. The mistake. An agent approaches and says, "Let me see your ID." The worker reaches into their pocket, hands over their wallet, their foreign consular ID, their passport, their documents, voluntarily, without being legally compelled. That one reflexive action, just handing things over, can accelerate an encounter from a brief question into a full detention. The scenario. You are a warehouse worker. An ICE agent walks up and says, "Can I see some ID?" You hand over a foreign passport. The agent examines it, notes the visa stamp, asks when it expires. You answer. Within 4 minutes, you have provided the agent with everything needed to establish you are out of status. It was all voluntary. You were never legally required to produce those documents in response to that question in that moment. Why people do it. People are conditioned from ordinary life to hand over ID when someone in a uniform asks for it. It feels like refusal will escalate things. It feels suspicious to say no. But there is a legal difference between what an officer requests and what you are legally obligated to provide. Legal reality. Under federal immigration law, non-citizen adults who are in the United States are required to carry their registration documents with them if they have been issued one. However, the act of handing those documents to an ICE agent in response to a question before any lawful detention has been established is a voluntary act. The agent must have a lawful basis to detain you before demanding your documents as part of a custodial interaction. The Supreme Court's ruling in INS v. Delgado, 466 U.S. 210, 1984, acknowledged that individual workers can be briefly questioned during a workplace survey, but emphasized that agents approaching workers and asking questions does not automatically constitute a detention or seizure under the Fourth Amendment. That distinction matters for your documents too. If you are not yet detained, your document production is voluntary. Evidence problem. Once documents are in an agent's hands, the information on them is part of the encounter. An expired visa, a foreign national identification, a document that reveals status. These become immediate, documented evidence. And because you handed them over voluntarily, you cannot later argue the documents were seized without authority. Agents have a legal basis for that detention. At that point, state phrase 1 again. I am exercising my right to remain silent, and do not produce documents without first speaking to an attorney if at all possible. Why it works. This phrase forces legal clarity. It mirrors the framework the Supreme Court established in Terry v. Ohio, 392 U.S. 1, 1968, which requires that a detention be supported by reasonable suspicion of specific facts, not merely a hunch or a setting. Asking whether you are detained or free to go creates a record of the encounter's legal status. It does not obstruct agents. It does not give them grounds for escalation. It simply requires them to define what is happening legally before you take any further action. Bottom line, never hand over documents reflexively just because an agent asks. First ask, am I being detained or am I free to go? Let the answer determine your next move. Mistake 4, running, resisting, or physically evading agents. The mistake. Panic sets in. Agents are blocking exits. People start moving toward back doors, windows, emergency exits. Workers who had full constitutional protections 1 moment ago are now fleeing. And fleeing changes everything. The moment a person runs from immigration agents in a workplace, what was a voluntary encounter protected by the Fourth Amendment becomes something else entirely. The scenario. ICE enters a chicken processing plant. Workers scatter. Several people run toward a back exit. Agents pursue. The workers who stayed at their stations, said nothing, and invoked their right to remain silent are treated differently from the workers who ran. Fleeing gives agents independent justification to pursue and detain. Courts have consistently held that flight from law enforcement, in the right context, can contribute to reasonable suspicion. Why people do it. Fear is a powerful force. When armed agents in tactical gear enter your workplace, every instinct says move. People are terrified. They are thinking about their families. They are not thinking about legal strategy. But this is exactly the moment when physical stillness is the most powerful legal protection available. Legal reality. In Illinois versus Wardlow, 528 U.S. 119, decided by the Supreme Court in 2000. The court held that unprovoked flight upon seeing law enforcement officers in certain contexts contributes to the reasonable suspicion needed for a Terry stop. Applied in a workplace setting, a worker who runs from ICE agents may give those agents a basis for detention that did not exist 1 second before. A worker who stands still, stays calm, and says nothing has given agents nothing new to work with. The encounter must be resolved on the basis of whatever information agents already had, not on the worker's response in that moment. Additionally, physically obstructing or resisting agents, pushing, grabbing, refusing to move when lawfully ordered, creates exposure to criminal charges for obstruction or resisting a federal officer under 18 U.S.C. paragraph 111. Those are criminal charges separate from immigration proceedings with separate and serious consequences. Evidence problem. Body camera footage of a worker running, hiding, or resisting is powerful evidence used against them. It is used to argue consciousness of guilt, to justify continued detention, and to complicate immigration proceedings. It becomes part of the permanent record of the encounter. Agent psychology. Agents anticipate flight in high-pressure workplace operations. They position agents near exits, a practice documented in the historical record going back to the factory surveys described in INS versus Delgado, 1984, where agents stationed themselves near exits during surveys of Los Angeles garment factories. Agents expect panic. The worker who does not panic deprives them of a significant tool. The correct move. Here is phrase 4. You do not need to say it loudly. Say it to any agent who approaches you directly. I do not consent to this encounter, and I am exercising my right to remain silent. Then, stay still. Keep your hands visible. Do not reach into pockets. Do not move toward exits. Do not make sudden movements. If agents begin to physically detain you, do not resist. Say clearly, I am not resisting. I do not consent. Then stop talking entirely. Your attorney will handle the rest. Why it works. Staying still, keeping hands visible, and invoking your rights on camera creates the clearest possible legal record. You have not given agents anything new. You have not created grounds for additional charges. You have not escalated the encounter. You have placed the entire burden of legal justification back on the agents, and you have protected yourself from the single most common and most damaging mistake workers make in these situations. Bottom line, never run, never resist. Stay still, stay silent, keep hands visible, and invoke your rights clearly and calmly. Flight creates justification. Stillness with invocation is your constitutional protection. The 4 phrases. Memorize these. Here they are one more time. Print this. Put it in your wallet. Practice these until they come out automatically, because when ICE is in your building and your heart is pounding, you will not have time to think. You need these phrases to be automatic. Phrase 1. I am exercising my right to remain silent. Use this the moment any agent asks you any question about your status, your origin, your documents, or your employer. Phrase 2. What type of warrant do you have? Is this a judicial warrant signed by a judge? Use this if you or anyone near you is being asked to open a private area of the workplace to agents. Phrase 3. Am I being detained or am I free to go? Use this before producing any documents or engaging further with any agent. Phrase 4. I am not resisting. I do not consent. Use this if agents begin to physically detain you while remaining completely still and compliant. Here is the truth about workplace ICE enforcement actions. They are not conversations. They are legal operations, where every word you say, every document you hand over, every door you open, and every step you take can reshape what happens to you next. The Constitution does not protect people who panic. It protects people who know their rights and invoke them calmly, clearly, and in time. Whatever your status, whatever your background, whether you are a citizen who happens to be in the building, a legal permanent resident, a visa holder, or undocumented, the Fourth Amendment and the Fifth Amendment belong to you while you are on American soil. That is not an opinion. That is established Supreme Court precedent, confirmed in Zodvitas versus Davis in 2001, and built on a constitutional framework that dates back to Wong Wing versus United States in 1896. Know your phrases. Stay still. Say nothing else. Share this with everyone you know who works in industries where enforcement actions happen. construction, food processing, agriculture, restaurants, hospitality, cleaning services. These workers deserve to know their rights before the door opens. This is educational content only. It is not legal advice. For your specific situation, contact a qualified immigration attorney immediately. The National Immigration Legal Services Center maintains a directory of free and low-cost immigration legal services across the country. The people who survive these moments are not the ones who talk the most. They're the ones who know exactly what to say and exactly when to stop. Stay informed, stay protected, and know your rights before you need them.